Sometimes a huge legal showdown can start with a really simple question. In this case, it was, can a regular citizen see a politician's university degree? And wow, that question sparked a massive battle in India, a real tug of war between two fundamental rights, our right to information and our right to privacy. So we're going to unpack a major high court ruling that might just change how you think about transparency and personal data forever.
So let me just ask you, straight up, do you think you should have the right to see a public figure's degree? Yes or no? Whatever your answer is, just kind of hold on to it, because that feeling is right at the heart of this entire legal conflict. All right, here's the roadmap for our story. We'll start with the simple question that lit the fuse. Then we'll look at the two sides duking it out, the argument for transparency versus the university's wall of privacy. We'll even get into a pretty wild fight over 10 rupees. And of course, we'll land on the High Court's final verdict and figure out what it means for your right to know.
Now, this wasn't just one big case. It was actually a whole bunch of them, all kicked off by ordinary citizens using the Right to Information Act, filing RTIs. They were asking for what, on the surface, seems like pretty basic information about the education of some very well-known people. And, the requests were all over the map. One person asked Delhi University for the BA results of every single student from the year 1978. That's a huge ask. Others were much more targeted, asking for the school records of a sitting union minister, Smriti Irani, and asking for details to verify Prime Minister Narendra Modi's degree. So you can see, these weren't just random questions. People were trying to verify the credentials of those in power.
So the first official body to weigh in on all this was the Central Information Commission, the CIC, and they came out swinging for team transparency. They ordered the universities and the school board to hand over the information, and the reasoning was, incredibly direct.
And this quote right here, it perfectly sums up their whole point of view. The CIC basically said, look, a university degree isn't some private secret. They compared it to a property deed, a record that's created by a public body, and because of that, it should be open for anyone to see. For them, getting a degree wasn't a private matter. It was a public record. So to back this up, their logic had four key parts. First, giving out a degree is a public activity. Think about a big convocation ceremony. Second, the university's official records are legally considered public documents anyway. Third, this all ties into a voter's right to know who they're voting for. And this is a big one, they said a university doesn't just hold a student's data in trust, it creates that data as a public record. But Delhi University and the CBSE saw things completely differently. They flat out refused to release the information. Instead, they took the fight to the High Court, and they built their argument around the idea of privacy and what they saw as a sacred duty to protect their students' information. This slide just lays out the clash perfectly. On one side, the CIC is yelling public record, and on the other, the universities are yelling personal information. One side says it's a public activity, the other says it's a relationship of trust. The CIC claims it's in the public interest, while the universities argue it's a massive invasion of privacy. At the end of the day, it all boiled down to how you interpret two very specific exemption clauses in the RTI law. Okay, so the first big legal concept here is a fiduciary relationship. It sounds complicated, but it's not. It just means a relationship built on trust, where one person has a duty to act in the best interests of another. Think of a doctor and a patient. The universities were arguing, hey, we are fiduciaries for our students. They trust us with their personal academic data, and we have a duty to keep it confidential from the world. And the second piece of their argument was this part of the law, Section 81J, the privacy exemption. This is a really powerful clause. It says you can't disclose personal information if it's not related to a public activity or if it would cause an unwarranted invasion of privacy. The universities basically said a student's grades and degree are the very definition of personal information, and giving them out to just anyone would be a slam-dunk violation of this rule. Now, right in the middle of this huge philosophical debate about rights and privacy, the whole thing got sidetracked by something almost ridiculous. It had nothing to do with privacy or the public interest. It was all about how someone paid the application fee. Get this. This entire procedural mess was over 10 rupees. 10. That's about 12 cents in the US. This tiny amount became a major point of contention in court, which just shows you how intense this fight really was. So here's what happened. Delhi University actually rejected some of the applications, not because of privacy, but on this tiny technicality. The 10 rupee postal order, the fee, was made out to the public information officer, but apparently it was supposed to be made out to the registrar. And for that, they sent the application and the 10 rupees right back.
Yeah, the Information Commission was not amused. Not at all. They slammed the university for it, using the old saying, penny wise and pound foolish. They basically called them out for spending a fortune on lawyers to fight over a 10 rupee mistake. They even slapped the official who did it with a 25,000 rupee fine for trying to block the process.
So, after years of back and forth, the whole thing finally landed in the Delhi High Court. It was up to Justice Sachin Datta to settle this fundamental conflict between our right to know and our right to be left alone. And everyone knew whatever he decided was going to be a really big deal.
And the verdict came down like a hammer. Privacy prevails. The High Court sided completely with the universities. It struck down the CIC's orders and basically said, nope, you don't have to release this information. It was a huge win for the argument that your school records are in fact private.
Now, the judge's logic really hinged on this brilliant little distinction, the difference between what the public is interested in and what is actually in the public interest. He argued that just because a lot of people are curious about something, that doesn't automatically mean its disclosure is essential for the public good. And that curiosity, he rolled, simply isn't powerful enough to trample someone's fundamental right to privacy. So the court basically went down the list and checked every box for the universities. It declared that yes, your degree details are personal information. Yes, the university has a fiduciary duty to protect them. And no, your right to privacy doesn't just expire after 20 years. And even on that 10 rupee issue, the court sided with the university, calling it a procedural mix-up, not a malicious act, and it threw out that fine against the official.
Okay, so what's the big takeaway here? What does all this mean for you and me? Well, this wasn't just a ruling about a couple of degrees. This was a landmark judgment that really tilts the scales for the entire right to information law in India.
So, the bottom line is this. An individual's privacy just got a lot stronger under the RTI Act. The idea of public interest has been narrowed, so you can't just be curious anymore. You need a much stronger reason. And it confirms, once and for all, that your educational records are considered private information held in trust by your university.
And this whole case leaves us with a huge question, one that we're all grappling with today. In this age of endless data, social media, and public figures living their lives under a microscope, where exactly do we draw that line between the public's need to hold people accountable and an individual's fundamental right to have a private life? This judgment drew a pretty clear line in the sand, but you can bet this debate is far, far from over.